I just want to talk very briefly about this. And again, I'm not an attorney. It's the first time I've done this. But I wanted to talk about this issue. Are gag orders constitutional? What should you do with a gag order? This was to the Supreme Court, and it was a mandamus petition. It presented two separate issues. One was whether the trial court had clearly abused its discretion in ordering the temporary placement of KDP someplace. The second is whether the court may review, in the first instance, the trial court's plainly unconstitutional gag order. Hear that? Plainly unconstitutional gag order. Plainly unconstitutional gag order. But the court put this out. And the attorney asked the judge to do this. Plainly unconstitutional gag order, but the judge went ahead and did this. But the thing again is that because there was no record of objection, they really, the Supreme Court really couldn't consider this. But the Office of the Attorney General seemed to give some guidance to the pardos, like to say, well, you can't do it here, but here's another route you could go. And I believe that the Office of the Attorney General also gave guidance to anybody who's facing a plainly unconstitutional gag order in a family court, what we can do to fight back. What is a gag order? The gag order, basically what it comes down to, it is a restraint on your free speech. And it's a prior restraint. It's a restraint on speech that you have not yet uttered. We have freedom of speech in our Constitution. We have even greater freedom of speech protections under the Texas Constitution. For a judge to say, well, I am going to gag you, they are violating your constitutional right to free speech. The gag order is a prior restraint on speech. And in this particular case, they said it was overly broad and it cannot be squared with the First Amendment's free speech guarantees. It cannot be squared with the First Amendment's free speech guarantees. Nothing prevents the trial court from correcting its erroneous gag order, which clearly contravenes free speech guarantees. What I want to bring to the attention of, though, is that judges hand out gag orders like they're candy. You know, it's like, you want some trick or treat? Here's some candy for you, some candy for you, some candy for you. Judges will often hand out these gag orders like they are candy to be given out at Halloween. And they are clearly unconstitutional violations of the First Amendment of our free speech rights. Gag orders restrict access to information by prohibiting individuals from discussing the case. Prior restraints on speech and publication are a most serious and least tolerable infringement on the First Amendment rights. And there is case law that's being cited with all of this as well. Gag orders are presumptively unconstitutional and entail a heavy burden on the state actor to prove otherwise. The gag orders are presumptively unconstitutional and entail a heavy burden on the state actor to prove otherwise. And what they're saying is this: if somebody puts a gag order upon you, the burden of proof is upon them to show why the gag order is legitimate. You do not have to. The burden is on them. Sometimes in these courts they change it around, so like somehow you have to show that the burden of proof is upon you. It's not on you. This is a constitutional guarantee, both by the U.S. Constitution and by the Texas State Constitution. The burden of proof is on the state or the state actor as to why this unconstitutional order should be placed upon you. They have to provide the burden of proof, not you. And it's not just in this interest, in this specific item, but there's many times that they try to make you like, well, prove otherwise. I don't have to prove it. You have to prove it. You're the actor, you're the state actor, and you have to prove why your case against me demands such actions as you're taking. Anyway, once again, this is continuing on here. They keep on talking about this. The order is plainly unconstitutional. The order is plainly unconstitutional. Plainly unconstitutional. It's not like it could maybe be constitutional. Well, we'll have to really consider this to find out if it's unconstitutional. It's plainly unconstitutional. It is plainly unconstitutional. And yet judges, at the urging of their attorney buddies many times, hand these things out, like I said, as if they're Halloween candy. So what it did, it deprived the parents of the ability to use any form of media, to share with their friends, loved ones, physicians, or religious advisors any information regarding this child or its case. So, and this will come up later on in just a few moments regarding the nature of the gag order itself. Gag orders are prior restraints subject to the stringent First Amendment standards, notwithstanding the state interest in protecting children. Well, we're given this gag order because we want to protect the children. That everything is done to protect the children. We think the gag order is in the best interest of the children. The best interest of the children is nowhere defined. The best interest of the child is an opinion, and it's an opinion often given by strangers who don't know the parents and who don't know the children. And once again, fit parents have the right to determine certain things, and the state has to overcome its presumption, its burden to say, we're going to tell you what the best interest of the child is. They cannot do this. And this is in case law. This is also considered a fundamental liberty issue, fundamental right. Although the text of the First Amendment is directed toward Congress, the U.S. Supreme Court has held that it applies to state actors. So we love to go to the court, to case law and stuff like that, and say, well, the court has said this, the court has said that. The Supreme Court says it's not just Congress, state actors. A judge is a state actor. A judge has to adhere to the same standards and provide the same protections that our Congress does under the First Amendment. It applies to the states through the 14th Amendment. The First Amendment protects democratic self-government, the search for truth, the free exchange of ideas, and the individual's interest in self-expression. Protection against prior restraints on speech is at the core of the First Amendment. So when a gag order is put upon you, they're trying, we don't want you to talk about these things. That is a prior restraint of your free speech that goes directly against the First Amendment. So on face value in itself, it's completely unconstitutional. The chief purpose of the guarantee is to prevent previous restraints upon publication. Prior restraints are disfavored because by definition they have an immediate and irreversible sanction. The special vice of prior restraint is the possible suppression of constitutionally protected communication before an adequate determination of its constitutionality. Because of this severe consequence, prior restraints are evaluated with a heavy presumption against their constitutional validity.